This audience is awesome. I have to say, it's wonderful to see everyone here this evening. So, welcome to the 2013 public lecture for Ryerson's annual Social Justice Week. And in addition to this excellent, phenomenal turnout, like yourself, I very much look forward to hearing Professor Kimberlé Crenshaw. But before we move forward, I'd like to also acknowledge that Ryerson sits on the traditional territory of the Mississauga's New Credit First Nations, and I appreciate their generosity in allowing us onto their territory. Chimigwich. As Winnie said, I'm the Assistant Vice President, Vice-Provost of Equity, Diversity, and Inclusion. The mandate of the Office of Equity, Diversity, and Inclusion is to identify and address systemic barriers, create a visible presence for equity, diversity, and inclusion such that it's integral to both the academic and administrative functions, play a central role in EDI educational initiatives, as well as engage the Ryerson community in building and fostering an inclusive environment for all to learn and work. Now, who of you would take on that job all by yourself? It is not a job for just myself or my staff or the division alone. It is the job of the entire university to endeavor to infuse EDI throughout our entire organization in how we live and work. And I have to say that I'm so very much looking forward to Professor Crenshaw's lecture, and given the focus on race, law, and social justice, as you might have noticed, I don't quite sound Canadian. And some people wonder if I'm Jamaican. I don't quite sound Jamaican either, but I wouldn't mind that at all. But I am from the United States. And given just within the short few months that have passed with the Trayvon Martin shooting, with the decision of the U.S. Supreme Court regarding voting rights, as well as affirmative action, that touches me deeply. Not only myself, my family, my neighborhood that I come from, as well as many others throughout the country. And I don't assume that similar types of situations have happened here, with the recent shooting of the young man on the bus. Also, Aboriginal women gone missing, and not much attention being paid to it. So my question to you in the audience and to Professor Crenshaw, as well as the other two who will be responding, what is our responsibility as educators, as a university, to inform through our research, through our service, through our teaching, so that these types of situations do not continue? We cannot just say our hands are free and we have no responsibility. While I just shared with you those 4 objectives of our mandate, it really means nothing if these type of situations continue. We have to consider that as also a part of our mission. And so, with that said, I want to acknowledge and thank Professor Winnie Ng for pulling together such a wonderful event. Let's all thank her for her efforts. Professor Crenshaw has a bio that anyone would envy. Let me just share a little bit of that with you this evening. Kimberlé Crenshaw, professor of law at UCLA and Columbia Law School, is a leading authority in the area of civil rights, Black feminist legal theory, and racism and the law. Her articles have appeared in the Harvard Law Review, National Black Law Journal, Stanford Law Review, and Southern California Law Review. She is the founding coordinator of the Critical Race Theory Workshop and the co-editor of the volume, Critical Race Theory: Key Documents That Shaped the Movement. Crenshaw has lectured widely on race matters, addressing audiences across the country, as well as in Europe, India, Africa, and South America. A specialist on race and gender equality, she has facilitated workshops for human rights activists in Brazil and in India, and for constitutional court judges in South Africa. Her groundbreaking work on intersectionality has traveled globally and was influential in drafting the Equality Clause in the South African Constitution. Crenshaw has worked extensively on a variety of issues pertaining to gender and race in the domestic arena, including violence against women, excuse me, structural racial inequality, as well as affirmative action. She has served as a member of the National Science Foundation's Committee on Research Violence Against Women and has consulted with leading foundations, social justice organizations, and corporations to advance their race and gender equity initiatives. Twice awarded Professor of the Year at UCLA Law School, Crenshaw received the Lucy Terry Prince Unsung Heroine Award presented by Lawyers Committee on Civil Rights Under Law and the ACLU Ira Glaser Racial Justice Fellowship from 2005 to 2007. Crenshaw has received the Fulbright Distinguished Chair for Latin America, the Alphonse Fletcher Fellowship, and was a fellow at the Center for Advanced Study in the Behavioral Sciences at Stanford University in 2009. Not only that, she was a visiting professor at the European University Institute in Florence, Italy in 2010. Currently, Crenshaw is the faculty director of the Critical Race Studies program at UCLA Law School. Please join me in giving a hearty welcome to Professor Kimberlé Crenshaw.
Good evening. There's so many thank yous before I even get started. Thank you to all those who give me permission to be here. Thank you for all those who invited me to be here. Thank you to all those who opened their arms to me so warmly when I arrived here. And thank you to all of you for coming out to share this evening with me. I am actually overwhelmed, quite frankly. And as so many of the folks who were at the reception reminded me, this is a pivotal moment here. And so I'm actually more anxious than usual. So I'm just going to say that and hope that it dispels the anxiety. I'm also really excited to be here, coming at the heels of a summer for us in the US, which is probably one of the most consequential summers that we've had in a very long time on issues pertaining to racial justice. So I come here as a traveler from the South. I'm coming here to share with you what I call scenes from a summer of racial injustice. I'm going to frame it somewhat as a museum piece of what post-racialism and the law looks like in our neck of the woods. Now, at the outset, I do want to pause and appreciate, especially given all of the energy, all the hard work that Winnie, Denise, Grace Edward, all of the co-sponsors have put into creating this very special space to be able to talk about these very important issues. I want to pause for a moment because in the United States, it is not entirely clear, at least not to me, that within the space of 3 years, 5 years, or even 10 years, that this kind of event will still be seen as important or even legally permissible. And if you take seriously, as I hope you will, some of the challenges that have been presented by this summer in the US, you will, I hope, come to see that this just isn't a grievance, but this is a call to action for all of those who are concerned about, committed to maintaining the space for discourse around social justice, and in particular, discourse around race in that social justice discussion. So I want to explore in the time that I have with you some of the dimensions of this historical moment that are playing out in the United States, mindful of the possibility that they might sound familiar or wildly divergent from some of the discourses and events that are happening here in Canada. So to further engage this argument around racial justice, or to bring you into the museum pieces that I'm hoping to present, I'm doing so as a curator through the lens of critical race theory. So critical race theory is both a direct product of the arguments that I'm going to discuss, and also the frame that I'm going to use to talk about some of the implications of these issues across the legal and social terrain in the United States. So in particular, I want to address how critical race theory's historic struggles in law schools over the question of the scope and the meaning of equality against the backdrop of colorblindness parallels some of the struggles that we are engaging around diversity today against the backdrop of post-racialism. Now, the irony of all of this is that some part of this backdrop of post-racialism is attributable to a spectacular, and some would say unprecedented, success that brought about what we now call the age of Obama. Many years ago, during the earliest stages of critical race theory, I argued that winning and losing were actually part of the same experience. I argued furthermore that transformation sometimes spelled the demise of movements that brought about the change in the first place. Now, I called in that instance for an analysis of racial power that paid attention to the contradictory nature of racial progress. Well, the Obama era is a dictionary definition of precisely that issue. As Derek Bell argues, racial dynamics are not organized as an inevitable forward march, but instead by forward and backward dimensions, sometimes happening at the same time. So, set in this light, post-racialism is a modernist take on colorblindness, one that reflects this simultaneous push and pull, one that is being made possible largely by this transformative moment, symbolically, of having elected Barack Obama, and at the same time, racial contradictions rising to a level that we've not seen in quite some time. So all these arguments come together somewhat ironically around questions of affirmative action in college admission, but also more broadly in arguments about voting rights, about stop and frisk, and in the case of Trayvon Martin, racialized notions of criminality and the justified killing of an unarmed teenager. Now, in reflecting on the unraveling of the tapestry of civil rights at all levels, I want to show how notions of diversity have been tamed and disciplined under the weight of colorblind ideology. And I want to tie this taming to the broader project of insulating the status quo from any significant measure of racial change. So here's my itinerary. I want to posit that the question of race and inclusion within the broader constitutional framework tells us a lot about the polarities against which current discourse around race madly goes back and forth between. Simply put, the discourses around race and inclusion that came to a head this summer reflect profound polarities of thought about whether racial inclusion, diversity, integration, equality actually matter. And the ascendance of one of these views, which I will refer to as colorblind ideology, has played a vital role in shrinking the available real estate around which constituencies who care about racial justice inclusion can actually make forward movement. Now, finally, this is not just a story about racial inclusion, it's also a story about the law. And I want to make the law front and center in this, in large part because many times people are of the assumption that law stops doing its dirty work once segregation is over with, or once explicit discrimination is over with. And so what I want to use critical race theory to do is bring to the forefront the role that law continues to play in authorizing racial stratification, in making efforts to challenge racial stratification ever more difficult, and in normalizing a racially unequal status quo. So I want to start with a backstory about how we came to this particular point in the US and what perhaps has been lost along the way. Now, I often start with two competing images, and I want to give you what the subtext of those images are, and then I'll tell you who the authors of this image are. So one image is an image that begins with a quote, "We've come to this point to present a promissory note, to ask for the promises that have been given to us to be cashed. We come to create the demand to make real the promises of equality and inclusion." That's one idea. Another idea is that there are no debtors, there are no creditors, there's no race that owes anyone anything. We're all here and we're all just Americans. These are two different ideas, right? This is my first image in my museum. So the person who was responsible for the first quote is Martin Luther King. And it is the argument that he made on the steps of the March on Washington, the 50th anniversary that we just celebrated in July. And it was basically a statement that our American society is one that is in need of repair. Namely, it was a demand for reparations. It was a demand against a baseline that assumed that the existing racial disparities that existed at that time, and that they were broad, through all industries in any number of other measures, from health to wealth to education to segregation, there were massive disparities that this particular claim made violated some of the basic understandings and promises of the 14th Amendment. So the idea was, we're coming here to cash a check. It's been a bouncing check for over a generation, but it's a check whose time has come. So it is an idea of repair, an idea that something is owed, an idea that the level of disparity is not natural, and that if we treat it as though it's natural, that that is a continuing injury that runs counter to the fundamental promises of the 14th Amendment. The position on the other side is our current Supreme Court Justice, Antonin Scalia. And he made this statement in a case in which the Supreme Court overturned a modest measure under an affirmative action policy to provide for bidding opportunities for non-traditional firms to be able to win government contracts. And what his argument was is basically, there is no deficit, there is nothing in disrepair, there's nothing owed, nothing due. The only thing that we have is America. Right? So there is no bounce check, and if there was a bounce check, then we're going to end the check for good. The account is dry. There is nothing else to give along this particular set of demands. Now, this argument also comes with a sociological claim made also by Justice Scalia and Justice Thomas, that this pursuit of unwarranted repair, whether it be through diversity policies at the university level, whether it be through affirmative action policies at the federal level, even if it's a voting rights law, all of these efforts to repair something that is not fixed creates a greater problem, and it is a problem of preferential treatment. It's a problem of reverse discrimination. It's a problem of creating an attitude and discourse of entitlement among those who see themselves as being owed something. So this sociological kind of claim marries with a colorblind ideology on the part of the Supreme Court that renders certain kind of questions that we might all ask here to be irrelevant and potentially unconstitutional. Questions like, what can be done to increase the number of students or faculty of color? What can be done to increase the participation rates of minority businesses? What can be done to improve the educational opportunities for traditionally excluded groups? All of these kinds of questions under this particular framework are problematic questions because they invite policies, they invite consciousness, they invite interventions that are seen as falsely redistributive, reverse discrimination, preferential treatment. So this museum piece, these two figures talking to each other, represent the great polarities in anti-discrimination law, in constitutional law, and also in public discourse around race in the United States. Now, the point of this departure, first of all, is to highlight how many of the issues that we talk about all the time are actually weighed against an ideological scale, not necessarily one that measures the extent to which the disparities are real. So we often give statistics about the participation rates of people of color. We talk about pipeline issues like K through 12 experiences. We talk about lack of access to effective preparation. We talk about the efforts to standardize access through standardized tests that actually have a cultural and gender effect in excluding certain people from even being able to compete. We talk about psychometric factors connected to testing bias, implicit bias, stereotype threat, poor mentoring. These are all conditions that create anything but a level playing field. But ideologically, all of those issues may not matter if a court or a law says that it has to be colorblind. We cannot pay attention to the way race shapes opportunities throughout the social plane. So this thinking is thinking that critical race theory has long engaged, and in fact was the point of entry for critical race theory to come into existence. So I want to tell a quick story, and I want to do this particularly for the students, in part because I think the story of how critical race theory comes about is not simply a story of contestation against a particular set of ideas around the irrelevance of racial disparity, although that's one important dimension of the story. It's also a story about how students in a particular generation took a torch that was passed to them from a prior generation and took it into the institutions that had been opened for them by others, and continued the struggle of rethinking what racial equity looks like in institutions that were not shaped around or were not meant to be responsive to the needs of communities that had traditionally been excluded from them. So this also is a story about how I came to be a critical race theorist. Now, critical race theory emerged as a particular moment and a particular set of ideas in the 1980s, around the time that the first generation of students of color who had come out of many activists, campuses, and other kinds of movements gained access en masse to elite law schools. I was one of a group of students who matriculated to Harvard Law School in 19... and it was a period just after Derek Bell left Harvard Law School for the first time. He left a couple times, actually. And in this particular moment, many of us were coming out of lots of different ethnic studies programs, anti-apartheid struggles, public institutional struggles about making higher education available to a wider array of communities. So we all came to law school with an idea that law is where it's at. We need to figure out how to get the legal tools, the skills, the arguments under our belt so we could go out and be useful carriers of the spirit of social justice in our generation. And so naturally we went and thought we were going to be able to study under the great Derek Bell, not knowing that the summer before we got there he had said he'd had it, he was done with Harvard, and he left. They say Elvis is no longer in the building, Derek Bell was no longer at Harvard Law School, and we were not happy about it. So as students who had been growing a certain sense of how to go about engaging institutions, we thought, well, this is simply a matter of negotiating with the administration over what their plans were to offer the courses that Derek Bell offered, and while they were at it, why not try to further diversify the faculty? That was the main reason he left anyway, so why not do something about it? So many of us, representing a cross-section of all the student organizations of color, made an appointment with our dean, and sat down and more or less laid our claim. We are consumers of this education and we're paying through the nose for it. We came here with an assumption that you were prepared for us, you admitted us, you know what it is we do, you know what it is we expect, and we expect these courses to be taught, and we also expect for you to use this opportunity to recruit more scholars of color from across the country to integrate this august faculty. Now, our dean, an interesting character he was. He was a liberal. He was a member of the Legal Defense, the NAACP Legal Defense Fund Board, the organization that fought and won Brown versus Board of Education. I think saw himself generally as an ally to racial justice. He also saw himself as the defender of standards. He also saw himself as the gatekeeper, to the hallowed halls of Harvard Law School. And he saw himself finally as an educator. So we were potential leaders of tomorrow. This was a learning moment for us. So he was going to walk us through the paces to show us why our expectations did not meet the reality of the situation. So the first question he asked us was, what's so great about this course that Derek Bell teaches, constitutional law, and minority issues, that you can't get from taking a basic course in constitutional law and maybe going down to the Legal Aid Society and taking up a few cases from the folks there? Doesn't that basically give you essentially what it was that Derek Bell would have taught? And the second question, and that gets to the core of the matter, wouldn't you prefer an excellent white person over a mediocre scholar of color? And so my museum piece number 2, right? The excellent white professor over the mediocre scholar of color. Now, this was meant to be a Socratic dialogue. By that meaning he was asking us questions and we were supposed to recognize the error of our logics and say, oh, our bad, we're gone, right? And what it in fact did was it created for us a nice little subtext, something that we could read. It made the conditions at Harvard Law School legible to us, right? They articulated in line and verse why this institution continued to look the way it did. It was not an accident. It was a product of a certain ideology around what counted as qualification, what counted as excellence, whose communities are being served by this institution, and importantly, whose communities were not being served. What that did for us, in addition to liberate us, It told us that we needed to find an alternative course. By that we meant an alternative way of making clear what our expectations and demands were, but an alternative way of actually having them met. So rather than begging, cajoling, protesting, sitting in, we decided to put all of our resources together and create what we called the alternative course. Surely there were scholars of color all over the country who had a particular background and understanding around how race and law functioned, either as advocates, as subjects of race and law, or as those who researched it, who were not coming under, in their view, as qualified to be there, in part because they did not see these issues as important. So we pooled our resources. We identified 12 scholars across the country. We brought them in, one per week. We all read a chapter of Derek Bell's book, and we basically taught ourselves. It was liberation education at Harvard Law School. It was also the beginning of critical race theory. Because one of the things that happened was we all became aware of, as a cohort, of the same kind of texts that were in existence at the time. And these texts did important things with respect to the law that traditional texts did not do. They interrogated its baselines, its basic themes, its basic principles. It challenged the idea that we always had to measure racial justice against some other value that was equally or more important, like federalism, or existing rights and entitlements, or stability, or the economy, or the market. These were all things that were always used by other scholars to say, the only way we can come up with interventions is if we can find some that fit within these pre-existing values. Well, those pre-existing values themselves were repositories of racial power. Federalism in our country is clearly a repository of racial power. The idea that invested rights in seniority in a situation where no other people other than whites could have competed for the job, that's not a race-neutral value that can be balanced against racial equality. That's racial inequality. Either it stands or it collapses in the face of the demand for greater racial justice. So many of the scholars who came to present to us opened up the possibilities of thinking about law differently. It also opened up the possibilities of thinking about qualifications differently. So we looked at the faculty, and the faculty included basically a lot of white guys who had studied law, practiced law, theorized about law, created law in a period of apartheid. Now, as smart as these guys were, and they thought themselves to be the smartest ones of the bunch, they were at Harvard Law School, they were not smart enough to figure out how to deal with the biggest contradiction we were facing as a nation. Namely, we claim to be a nation about equality and democracy. In reality, we were a nation of segregation, of genocide, of slavery, and we were still dealing with the aftermath of that in the law. They could not figure out a legal approach to making real these promises. If you want to know where the brilliance of the social transformation around Brown versus Board of Education came from, it didn't come from the folks at Harvard. It came from the folks at Howard, right? The places where people were seen as being qualified to do the work based on the fact that it was new work. It was asking us to think new ideas. It was asking us to engage the law in different ways. So our demand as students was for that sensibility to be brought into the middle of Harvard Law School. Our demand as consumers was that we were going to be educated to perform the task that we thought we were there to do. That is to provide some kind of service, benefit to our communities and to the broader objectives of social democracy. So it was from that moment of pushback that we were actually able to push forward. It was from that moment that critical race theory came into existence, and it is that set of ideas that we use to interrogate, challenge, and hopefully resist against the ongoing nature of pushback at the Supreme Court level. Now, I don't want to present this story as a unique story. And in fact, what I want to do now in my second museum piece is broaden the story around struggles around diversity in higher education, and remember some things that have been forgotten. So when we think about the civil rights movement in the US, we tend to think about it primarily in terms of voting rights. That is the story that produced the pictures that were broadcast around the world. When Bull Connor decided to turn water hoses and tear gas on civil rights protesters who were simply demanding the right to politically participate in the exercise of the franchise. So these are these images that we have about what the hardest fought battles were, where the most bloody battles were. We still know about 3 civil rights workers who were killed, who were lynched when they basically went to try to assist African Americans to register and vote. So that rings very clear in our memories every time we have February. It's Black History Month in the United States. That's when we tell stories about the civil rights movement. These are the stories that we tell. There was another front line in the 60s that was every bit as bloody, every bit as trenchant, every bit as contested, but we don't think about it in the same way. And that is the struggle over racial inclusion in higher education. So just as many people were killed in struggles at the universities in the 60s as were killed in struggles over voting rights. The presidents of some of the most elite universities called the police to do the same kind of work that Bull Connor did on the William Pettus Bridge, right? Yet we don't think about these in the same register. And why might that be? One reason might be that it's far easier to stereotype the exclusionary desires of a Southern white sheriff than it is to interrogate the elitist desires of presidents and trustees of higher education, right? It was a lot easier for us to say those backwards folks in the South than it was to say those elitist exclusionary folks of the East. There are so many ways in which the struggle over power is solely seen as political power, when in fact, much of the struggle over power is over discursive power, over intellectual power, over the ability to name certain realities in ways that contest the traditional ways that our disciplines have thought about these. So this deeply contested battle has not really been very much a part of how we think about inclusion. We don't think typically about racial inclusion in higher education along the lines of those bloody battles in the 60s. Instead, we have this nice term called diversity, right? Right. So where did diversity come from? This is my museum piece 3. One of the consequences of this student activism was that many administrators in colleges and universities across the US, and I would be willing to bet in Canada as well, decided that in fact it was important to interrogate the barriers to higher education, that it was important to open up more possibilities for communities to be represented in these institutions. They saw these as important institutions for distributing the social good. And so they opened up a variety of measures, some of them admissions measures, some of them were special programs, summer programs that would allow people from underrepresented groups to come to a university, have some early instruction, and then on-ramp into the program. The University of California Medical School was one of those institutions. They ran a medical school that was largely all white until the mid and late 60s, and decided that they were going to have an affirmative action program. So what they did was they set aside 16 seats out of their class of 100 for students of color to compete, 16 seats out of 100. It worked pretty well. It turns out that those people who are most likely to serve communities of color as doctors are doctors of color. It turns out that if you actually want to improve the service delivery of communities of color who have historically not been able to enjoy the same level of medical delivery of services, the best way to do that is actually to create more doctors of color. If you want to change the nature of the profession, if you want to change what kind of diseases they think are important, what kind of delivery of medical services they think is important, you actually diversify the profession. So University of California decided that that's exactly what they were going to do. So they argued, number one, we think this program is important to maintain because we have underserved communities of color in California. We think this policy is important because education has been segregated and it has undereducated communities of color. We think it is important because the medical profession has been segregated, and we want to be one institution that is taking it as its mission to integrate the profession. Those were all its main issues. And then it said, and also we're kind of interested in diversity. And we think we should be able to do this out of our First Amendment right as an institution to decide how to best educate our students. So this case goes to the Supreme Court. And the Supreme Court decides in a tremendously disappointing decision that the use of race to include, to bring these students into the University of California should be treated under the same standard as the use of race to exclude, right? So there's a symmetrical thing going on here. It's the same thing, right? And then the question is it therefore constitutional? Is there a good enough reason to allow the University of California to continue to discriminate in constituting its class? So the Supreme Court split. There were 4 who said race should never be considered at all, no matter what, in college or med school admissions. Another group who said, look, to try to make use of race for inclusion the same as exclusion is to mistake a no trespass sign for a welcome mat. They're just not the same thing. So you do the math. That's 4 on one side, 4 on the other side. Who do we have left? We have a justice called Justice Powell. Justice Powell writes what is now considered to be the decision in Bakke, and he tries to split the baby. And the way he splits the baby is he eliminates all of the justifications that have to do with racial justice. So the idea that minority groups are most likely to serve each other, that doesn't matter, right? The school can't do anything about that. The idea that students are underserved by segregation, that doesn't matter. The idea that we want to have a more integrated profession, that doesn't matter. None of those things that actually place affirmative action in a racial justice discourse mattered. One thing did matter, and that was diversity. That mattered because, well, the university should have a right to decide how it wants to constitute its student body, as long as it doesn't overly trammel the rights of innocence. So diversity actually came to fore as a loss, right? It's a loss against the broader racial justice articulations. So it's not surprising then that when we talk sometimes about diversity, people go, oh gee, that's a real limp approach to racial justice, because it is. It's a copy of a copy of a copy, right? It doesn't have the same resonance, the same brilliance. It doesn't rest on its own bottom. It's a watered down way of saying that institutions have responsibilities along the lines of racial justice. So some part of what we have been dealing with this summer is the defense of even that. So we got a real low bar here. It's called diversity. None of these other rationales function anymore as constitutionally relevant. And now universities have to come by and say to the court in a convincing way that diversity matters for some other set of mealy-mouthed reasons, right? So they can't really make an argument about social utility. They can't make an argument about social justice. They can't make an argument about fairness. What they have to say is, our students learn better when they're together. Well, yeah, they do. But that's not the principal reason why it matters whether or not people have full access to the knowledge-producing institutions that make up the universities of North America. So much of what's so dissatisfying is that there's so much effort being put into maintaining minimal standards of participation. And now the Supreme Court has told us that even that is likely to be eventually found unconstitutional. So a fuller scope of this argument is beyond what I can talk about tonight, but what I do want to talk about a little bit is what are some of the consequences of having access to these institutions for the kinds of issues that we particularly care about. And on this, I want to turn to some of the tragedies that happened this summer. So as you all know, there was a very sad event that happened in Florida when a self-appointed community patrolman saw someone who he thought was suspicious. Walking in the neighborhood. This suspicious person was Trayvon Martin. He was a teenager who'd gone to the store for a bag of candy and some iced tea. He was talking on the phone with his girlfriend when George Zimmerman saw him and mentioned that this creepy, he said, cracker was following him. And I say that because that there is reason to believe that in some part people are able to feel okay about what happened because Trayvon was the first person who racialized the situation. So he made this comment. At the same time, Zimmerman is talking on the phone to the police department. The police department say, cease and desist, back off, we've got this, we're gonna come. Zimmerman does not take heed, decides that he's going to chase the suspect on foot. Now, mind you, one is not a suspect walking home, right? He's not a suspect. And a private individual can't make someone a suspect. That's something that the state can do, not an individual. In any event, he chases Trayvon. There is some moment of fisticuffs, and shortly thereafter, Trayvon Martin is shot through the heart. Florida has something called stand your ground laws, which means that you have no duty to retreat, even if you can retreat without inflicting serious bodily harm on someone. And more broadly, just self-defense itself allows someone to use serious bodily harm if they objectively believe that they are in harm's way themselves. Right? So it's about what the person actually believed, not what was true. So the fact that Trayvon did not have a weapon, or the defense said he did weaponize a sidewalk, that he used the sidewalk to beat Zimmerman. But even though it turns out that he was innocent, the law can allow Zimmerman to be acquitted if he reasonably believed that he was in fear of his life from this 16-year-old. Now, this was the issue that was put to the jury. The jury deliberated for a very short while and came to the conclusion that George Zimmerman was reasonable in fearing for his life from this teenager. Now, there's been a lot of debate in the US about whether race had anything to do with the case. And if you talk about anything that's a poll, you know, polarity, that is a polarity. The people who think race had everything to do with it cannot understand what planet people are on who think that race had nothing to do with it. And the people who think race had nothing to do with it think that everyone who thinks it did, they're just doing racial grievance mongering. Right? This is another opportunity where all these people are taking a tragic event and racializing it and making it appear as though Zimmerman was racist, the jury was racist. We all know they weren't. So that's the level of the debate right now. What is it that scholars who are now part of the academy can tell us to help us think more critically about this debate. Well, what we know now is that there's a whole range of cognitive bias science that tells us that people are many times racially motivated when they have no clue that they are. No clue, right? But yet it's been shown in study after study after study after study. If you prime people with just the word African American or black, and give them an object identification test, right? And the object is either crime relevant or crime irrelevant. It's either a gun or a hamburger. If you prime a racial stereotype, they will far more quickly identify the gun, right? Than if you don't prime a racial stereotype. So this and many, many other studies form part of the new knowledge that tell us that race isn't just about, do I hate this person? Do I have bias? Am I motivated by race? It's about the associations that race plays to a whole range of things like criminality, danger, intelligence, veracity, truthfulness. All of these played out over and over and over again in the trial. The fact that Trayvon Martin's girlfriend was not seen as telling the truth. She said he was on the phone, he was scared. They completely disregarded that testimony. The fact that Trayvon Martin was probably afraid for his life and had a right to self-defense, that didn't even enter into it, largely because he was already criminalized as a threat. So a lot of this new knowledge that has been generated over the last several years is new knowledge that is actually the product of people having access to higher education, to the production of ideas that then circulate back into society to help us think more productively about race. So, museum piece number 4. What is the nature of the broader public discourse around race and inclusion, and how has it been made even more complicated by the election of Barack Obama? Now, one of the more challenging things that is happening now is that those people who are opposed to race-conscious remedies, whether it's affirmative action or even laws that create a certain kind of responsibilities on the part of institutions, have decided they're going to take it to the people, right? So their idea is, we're going to go to direct democracy. We're going to ask the voters to decide whether colleges and universities can actually take race into account in constituting their class. They see this again as reverse discrimination, so they're making demands that people go to the polls and vote to take away the discretion to create diverse environments. Now, you might ask, before you even get there, why do you still need race? Why do you need to take race into account to create diverse environments? How come you can't have one race-neutral measure and everybody gets into college based on whether they deserve to be there or not? So I have an answer to that. And I'm going to talk about another case. So another case that came up, it was called Grutter versus Michigan. It has to do with affirmative action at the University of Michigan Law School, and Gratz versus Michigan. It has to do with affirmative action in the undergraduate admissions process. The idea, the argument that was made was, it is unfair that students of color, applicants of color, get, when they just come in, when they first start, they get 20 points. And no one else gets 20 points. And that 20 points is a preference, and that preference is reverse discrimination, right? So that's their argument, and they were sticking with it. Now, if you think that admissions are basically race neutral until this moment of 20 points comes in, then you might agree. Okay, that's reverse discrimination. But what if you knew a little bit more about admissions, right? And you had a little bit more of a sense of, in fact, they're not quite race neutral. So if you actually look at the points that students could get, that University of Michigan gave to people, it would turn out that all of these points are actually points that white students are far more likely to have access to than talented students of color. So some of the points had to do with, did you go to a school where you had advanced placement opportunities? Right? Just if you went to that school, you get extra points. Not whether you were in the program, but whether your school was a school like that. Well, it turns out that that's something that is maldistributed by race in American society. The vast majority of AP courses are available to Anglo-Americans and not available to most students who go to racially segregated schools, right? That's one thing. Another thing was, if you're actually in those AP courses, you have the opportunity to get above a 4-point average. You just have that opportunity. You're competing with people who don't even have that opportunity, right? Another one is, if you happen to live in the Upper Peninsula, basically that means non-urban area students get another set of points, right? Which most students of color who don't live in those areas didn't get access to. So when you really added up all the points that white students had more access to than students of color, it was a difference between 28 points on one side and 20 on the other, right? So the question is, was it really a preference? Or did it attempt to offset a preference that was built in the traditional way that access was given, right? So that was what all the brouhaha was about. And at the end of the day, the Supreme Court decided in one case that 20 points off the top was reverse discrimination, notwithstanding the fact that there was deep discrimination in the actual distribution of the access in the first place. And in the other case, the court said, well, if you do it kind of like Justice Powell said in Bakke, just a little finger on the scale on diversity, you can manage it. Now enters those people who come and say, okay, that's not good enough for us. We want to make it sure that these folks at University of Michigan will never create an affirmative action program again. So we're going to go around, we're going to create this amendment process. We're going to go largely to communities of color and get them to sign to say that actually they believe in non-discrimination, right? So the way the language was framed was there should be no race discrimination or preference to anybody on the basis of race. Now that sounds pretty good, doesn't it? If you didn't know what was happening, you would say, yeah, I believe in that. And if it's called the American Civil Rights Institute, right? You would say, yeah, I'm on the side of civil rights. And if it's called the Civil Rights Amendment, you'd probably sign it, right? So that's exactly what happened. So thousands of people of color signed this petition. Some of them were even told that the NAACP was supporting it. There was one story where the president of the local NAACP was going into the supermarket. One of the petitioners came and said, would you sign this initiative? The president of the NAACP is supporting it. And she said, well, I didn't know that I'm supporting that, right? This was part of the evidence that was given around the question about whether this violated the Voting Rights Act. Long short of the story, the Michigan Civil Rights Initiative was passed with 58% of white women, 73% or so of white men voting for it, and the majority of people of color voting against it. And that's not the end of the story. It was struck down by a court who said, you cannot, as a majority, create a political process to take a particular kind of interest or policy out of the normal political process and put it above the heads of minority groups. It's like when you have a kid who, you know, is playing with something and you want to put it out of their reach and you put it on top of the refrigerator. That's essentially what the majority was doing. They were, by amending the Constitution, they were putting the access to affirmative action on the refrigerator so people of color could never ever get it again. And so the court said, you can't do this. You're singling out one group of people. You're saying that only people of color cannot have access to diversity, but veterans can, You know, sons and daughters of people who our legacies can. Any number of other groups have access to these policies, but people of color cannot. You cannot do that. So the next big case that's coming before the Supreme Court is this case, right? Everybody thinks that the end of this particular protection is likely to happen, with the Supreme Court saying, if we're simply taking away the right to do something that's color conscious, that's not discrimination, because everything should be colorblind anyway, right? So we're at a point where the Supreme Court has gotten into the act and has advanced the process of those who are making arguments against any kind of race consciousness. Now, I promised I would say a couple of things about Barack Obama and the role that he is playing symbolically in making all of this make sense. So colorblindness was yesterday's pushback. Post-racialism is today's pushback, right? Post-racialism plays two arenas where colorblindness was sort of like a supper club act, right? What makes post-racialism popular is its association with an immensely popular, or at least it used to be, character of a racially transcendent person, right? So people loved the idea that in voting for Barack Obama, and even those who didn't, I have to say, vote for Barack Obama, the fact that he won was enough for people to say, racial history is behind us, right? So there are even studies, again, psychological studies that show that those white Americans who voted for Barack Obama actually have opened up and are more willing to say things that used to be seen as racist because they have voted for Barack Obama, right? So he is a character that basically represents the idea that if we can break through the top, then nobody has anything to complain about all the way down through the bottom, right? So the idea is, if you can get up here, in the words of great social theorist Will Smith, no more excuses. So the idea now is that racial discourse, pointing out ongoing disparities, talking about the way that, once Barack Obama got elected and went to the White House, the number of African Americans in the Senate went from 1 to 0, right? That was not necessarily progress. But the idea stands that this great transformative moment tells us that we don't need talk about race anymore. How is this circulated in the academy? Well, in the academy, one of the serious things that is happening is that ethnic studies programs are now under assault in a lot of places. In Arizona, the state passed a law that abolished Chicano studies programs. Completely abolished it. And now they have a banned book list. I'm happy to say one of my books is on that list. But this is just a prism for us to understand both the ideological impact of colorblindness and the way it plays a role in knowledge production, right? So this is telling us how important it is that certain ideas not be allowed to circulate, and how effortless it is for some people, no matter how much they care about the First Amendment, to think that certain kinds of knowledge produced by and about people of color can be marginalized and pushed outside of legitimate discourse. So, where are we now, and what is the future? So, I have focused largely on colorblind ideology, particularly in law. I paid some attention to how colorblindness functions to justify a racially disparate status quo. I've talked a little about the kind of knowledge that has been produced that can be useful, and that we run the risk of losing if these efforts have more effect. But it would be wrong to suggest that the only thing that we need to do is say no to this or to push it back. in part because the discursive terrain in the media and elsewhere is also amplifying these ideas. So I have a picture, I don't know if we're going to be able to show it, of a Newsweek picture, which is all about affirmative action. And there's a picture of a young man. He's African American. He has some specs on. He has a nice little tie, he has a Gap shirt, probably Banana Republic pants. He's looking, you know, very collegiate. And the question is, affirmative action, do we still need it? 10 ways to think about it now. Am I going to get this picture? Maybe. Okay. And the question that's being asked is, how does this illustration help us think about whether the time has come for us to give up this discourse about racial inclusion and about diversity? The problem with the picture is that the picture actually gives you 3 ways of thinking about diversity that would suggest that we don't need it anymore, right? So one way that it tells you that it might not be needed is that it's just about race. It's not about anything else. It's not about gender. It's another way of saying it's not about class. Obviously, he looks like he is well-prepared middle class. And it looks like it's only about black people, right? Not about the hundreds and thousands of other people of color who've gained access to higher education. So it was 3 quick ways of telling us that we didn't need affirmative action anymore. Now, some people might say, well, look, what's the problem with just Newsweek deciding that it was going to choose someone who had something to do with the case, basically to throw him on the cover. It could have been him, it could have been a bunch of students at the student union, it could have been the president. What difference does it make? Well, here's the difference. This guy didn't have anything to do with the case. He wasn't even a student. He didn't even live in Michigan. He was just a model. And the clothes were clothes that the photographer put on him to actually tell the story. So the glasses weren't his glasses, the tie wasn't his tie. They said thank you to Pierre Cardin. You know, inside the cover, there were all the credits for where they got all the clothes. The point was that the media was trying to create a narrative, trying to tell a story. These are choices. The media wasn't just reporting, they were helping to constitute the story, right? So this is someone's vision, someone's image, someone's idea about what affirmative action is and why it's problematic, right? Now, these other 2 images also give us a sense of what those who are interested in racial inclusion are up against. This second one is the cover of a book. It's called Mismatch: How Affirmative Action Hurts Students It's Intended to Help. This is a liberal argument against racial inclusion policies. And the basic argument is, well, you can kind of look at the picture and tell me what the basic argument is, right? So tell me about those pencils. What's the difference between those pencils? What's the first difference you notice about those pencils? The color. And the one that's a different color, what do you notice about that pencil? It's dull, right? So, I mean, you really don't need to read the book to know what it's about, right? It's telling you. This is what circulates, right, as argument. Right? It's telling you that certain people just don't belong, and we're not doing them any favor in bringing them into our universities. Now, I have to tell you that one of the authors actually is a colleague of mine at UCLA, and needless to say, we've been having a lot of arguments about this argument. And this last person is Abigail Fisher. Abigail Fisher, this is my last slide, last piece of my museum piece, is the plaintiff in the last affirmative action cases. And her argument is basically that even though I cannot prove that I would have gotten in without affirmative action, I am still injured. Because I'm injured because race was taken into account. It injured my sensibilities, right? It hurt my feelings. And the Constitution protects me because the Constitution actually gives me access to color blindness. So the whole argument in this last affirmative action case is not about underqualified people of color. That's not what it's about. It's about taking race into account means that some people whose race is not taken into account feel as though they have been injured by participating in a process where something is valued that they don't have, even if they didn't have any of the other credentials to get in. This is what we're up against. So, my last thing that I want to share with you is a tool that we think that we want to offer that can help you think about this. And if I could get you to help one more time to bring up the video. So we think that what has to happen is people need to be able to talk about racial inclusion and push back against the idea that this is preferential treatment. You need to push back against the idea that this is unusual, push back against the idea that it's reverse discrimination. And it's important to realize that this isn't just a conservative liberal problem, right? Liberals who support diversity are as likely to use some of these bad arguments as conservatives do. In fact, the main difference in many arguments isn't how they describe it. Right? In many instances, liberals will say affirmative action is about giving a leg up to unqualified people because they need it, right? It's about, giving a preference because we want to have diverse institutions, but they don't challenge the fundamental idea around whether affirmative action is in fact preferential treatment. Well, we thought that it would be useful to remind people of the fact that affirmative action is simply removing obstacles. Diversity is figuring out what are the institutional features that prevent diversity and removing those, right? So when you remove something, you're not giving something to people that they don't deserve. What you're doing is you're removing the obstacles. So we wanted to tell a story about how if you take into account the obstacles that are already on the track, removing them is not. Okay, so I just want to end with challenging us to think about what kind of allies we can be to one another. So I've talked a lot about diversity, I've talked a lot about affirmative action. What I want to challenge us to think about is, what does this mean for the kind of allies we can be? So let's ask ourselves every day, what do we have to think about? What do we have to do to be reliable, real allies? That's, I think, the challenge at this post-racial moment. And it means that we have to be allies whose positions are firmly rooted in empathy, in mutual respect, in an understanding of injustice that cuts across intersecting forms of subordination, and one that helps us illuminate a vision of social justice that captures the lived experience of each and every member of our community. Thank you.